And a man convicted of terrorism in the murders of a Muslim family in London plans to appeal. 23-year-old Nathaniel Veltman was sentenced to life in prison in November in the deaths of 4 members of the Afzaal family in 2021. A 9-year-old boy survived after the family was intentionally struck by Veltman driving a pickup truck. A timeline for the appeal is unclear, but the law firm representing Veltman says that it usually takes about 1 to 2 years. And again, with this plan to appeal the convictions against him for murdering the Afzaal family, including the judge determining that it was terrorism. So let's bring in criminal defense lawyer Kim Schofield with more. Kim, thank you very much for taking time to speak with us. First off, how common or uncommon is it for any appeal like this to happen?
So I think especially in a homicide appeal, and this case, maybe even more particularly, we were all expecting an appeal. One of the reasons is, of course, the charge of terrorism was for the first time prosecuted in a homicide. So I think the Court of Appeal is going to want to weigh in on Justice Pomerant's decision, certainly. But the accused or the defense has some complaints about how this trial was run. And these complaints are somewhat unique to this trial. So if we could just back up and go through what the accused is going to say are the grounds of appeal. Number one, he's going to talk about his statement. So in order for a statement to be used against an accused, there has to be a legal or pretrial motion, a legal determination. And the judge found that this statement was admissible. His lawyers on appeal will challenge that judge's decision and say, in fact, that statement should never have gone before the jury. So that's the first ground of appeal. And then second, which is a little more interesting on many levels, is the Crown Attorney, in addressing the jury in final arguments, address the jury in a way that the accused says is vindictive, or the defense says was vindictive, that there was emotional content, gratuitous language, to the extent that it would then affect or cause bias on part of the jury. So the accused or and the defense on behalf of the accused applied for a mistrial. So they saw it so damaging to their position, so inappropriate, that they asked the judge to declare a mistrial. That, of course, was denied, but that will be, I think, one of the main grounds of appeal here.
Okay, so going off of what you just said, and then also this, this is the first time that Canada's terrorism laws were put before jury in the first-degree murder trial. Looking at that, yes. This is precedent. What grounds, how strong will this appeal be, given that, we're talking about precedent here?
Well, I think that there's certainly the appeal has merit because there really is no case law that we can point to say that Justice Pomerantz was either correct or incorrect in the instruction given to the jury and in her findings post-conviction. So I think that there's certainly grounds for appeal. Is this enough to order a new trial? Well, that will be up to the Court of Appeal to decide. But I think that the strength of the appeal really lies in the admissibility of the statement, because certainly if that statement was not admissible, then the Crown may have been in a very different position about the provability of that case. And then also the actions of the Crown in making such an emotionally charged address to the jury. That I think the Court of Appeal has weighed in on many other cases as well to say it's just inappropriate, that the Crown really has to have always a measured approach, especially in a case like this that is emotionally charged.
Okay, as we wrap up, given what you just laid out, how do you see this playing out?
Well, I'm not sure that there's enough to overturn the verdicts, frankly, but it's important, especially when someone is given life. It's important that a second look be given to all of the interpretations, and especially in a case like this when new law, in fact, was made. So I'm not sure there's enough to overturn this, But certainly there's grounds of appeal, and the defense may be able to make some headway, but I don't know that it's enough to either overturn it. But remember, there's two possible outcomes. One is that the conviction is overturned, very unlikely, or two, that a new trial is ordered. So if, in fact, the appeal is successful in any way, it would really end up, I think, in a new trial being ordered as opposed to a conviction being overturned.
Criminal defense lawyer Kim Schofield, always a pleasure. We got to get you in studio sometime. I know you're always busy.
We do. It would be my pleasure.